any case of the appellants. Now, there is nothing as far as I am concerned of any act at all. In fact, I was not in Delhi. No covert or overt act as far as I am concerned. I am in conspiracy, mother. That's the 59 FIR. I am innocent till I am proved guilty. And this is in the nature of a punitive act by the state to ensure that I continue to be in jail for a lesson to be learned by other students of the university that don't do any of this. After all, Mullahs, Chakka Jam is something that has happened throughout the country. Mullahs, I remember even during George Fernandez days. Your Lordships will remember. Railways, Mullahs, not allowed. The Kisan agitation, no UAPA for any of them. It's a valid protest. You may say it is in excess of what they should have done. You can say that. But you can't say it's a terrorist act. Now, I ask myself the question, an academic in an institution, what can he do to overthrow a country?
Yes.
Overthrow the state or whatever. So, Malad, therefore, now the question arises, as I showed to you, he relied on the speech only. Even in the High Court, he relied on the speech. That's the finding of the High Court. I just showed that paragraph to your Lordships. Yes, sir. He says, prima facie having delivered inflammatory speeches on communal lines to instigate a mass. Where is that? Where is this? Entire speech may be read. There is nothing stated on communal lines at all. And how does the High Court come to this conclusion? And kindly say, in contrast, although the co-accused persons named above were present in the conspiratorial meetings and were members of the WhatsApp groups, however, their role was limited when juxtaposed. What is my role? And whereas the allegations of these speeches were also against the co-accused, not just me. And those co-accused are on bail.
Yes, sir.
Now, I'll come back to the note, Malad. So now, Malad, so that takes care of the fact that I am entitled as a matter of law to seek parity on my facts, saying that the role attributed to me is even much less. And the only thing relied upon are the speeches. I've shown to your Lordship the speech he made, and nobody can call it, Malad, inflammatory.
Oh.
In any sense of the word. Now, Malad, I am otherwise also entitled to bail for change of circumstance. Now, Malad, I've given that. Now, Malad, I withdrew the SLP. The petitioner withdrew his SLP on 6/4/23 in the first bail application on 14/2/24. And thereafter filed a subsequent bail application on the basis of the following change of circumstances. 1. Parity with co-accused Asif Iqbal Tanha, Devangana Kalita and Natasha, which could not have been claimed when the trial court and the High Court denied the first application on 24/3/2022 and 18/10/2022. I could not have claimed parity, Malad. Then came Supreme Court order, the clarification. I withdrew and then claimed parity. This is because of the interim order of the Supreme Court. That's the first change of circumstance. Second, an increased period of incarceration undergone, Malad, because from 2022, we have now come to 2024, 25, 3 years went by. So, Malad, I'm entitled after 3 years to say, please, this is a change of circumstance, allow me now.
Yes.
So that's the second, Malad. So, and the third is change of law, but this is very important. In the meantime, there was change of law. And there are two judgments I want to point out to your Lordship. The first one is Vernon versus State of Maharashtra. It's part of my compilation. It says, Malad, it has emerged that accused 2 Vernon and accused 3 Ferreira and Sudha Bhardwaj, along with other accused, have recruited members for the banned terrorist organization. They are also active members of the said banned organization and have fulfilled the objectives of the banned organization by doing propaganda and dissemination through the medium of frontal organizations with the ideology of the organization. That's how it starts, Malad. Now kindly come straight away to paragraph 35 at page 118. That's very important. That's the change of law. Now, what does it say? In none of the materials which have been referred to by the prosecution, the act specified to in subclause A of 15(1) of the 767 Act can be attributed to the appellants, nor is there any allegation against them which would attract subclause C of section 15(1) of the said statute. As regards to the act specified in 15(1)(b) thereof, Some of the literature alleged to have been recovered from the appellants by themselves give hint of propagation of such activities, but there is nothing against the appellants to prima facie establish that they had indulged in the activities which would constitute overawing any public functionary by means of criminal force or show of criminal force or attempts by the appellants to do so. Neither there is allegation against them of causing death of any public functionary or attempt to cause death of such functionary. Mere holding of certain literatures through which violent acts may be propagated would not ipso facto attract the provisions of 15(1)(b). Thus, prima facie, in your opinion, we cannot reasonably come to the finding that there is any case of the appellants. Now, there is nothing, as far as I am concerned, of any act at all. In fact, I was not in Delhi.
All.
Right, but let's now kindly come to page 122. This is the change of law.
Yes.
Para 46 at 122.
Yes.
In Zahur Ahmad Shah Batali, it has been held that the expression prima facie true would mean that materials evidence collated by the investigating agency in reference to the accusation against the accused concerned in the charge sheet must prevail, unless overcome or disproved by other evidence, and on the face of it, materials must show complicity of such accused in the commission of the stated offences. What this ratio contemplates is that, on the face of it, the accusation against the accused ought to prevail. In our opinion, however, it would not satisfy the prima facie test unless there is at least surface analysis of probative value of the evidence at the stage of examining the question of granting bail, and the quality of probative value satisfies the court of its worth. So, one, you must analyze the probative value. You must also test the quality of that value and then come to the conclusion. And what does the High Court say? I showed to your lordships 144. That look, he made an incendiary speech, and that's good enough. And then it says, in the case of the appellants, contents of the letters through which the appellants are sought to be implicated are in the nature of hearsay evidence recovered from co-accused. Moreover, no covert or overt terrorist acts have been attributed to the appellants in these letters or any other material forming part of record of these two appeals. Reference to the activities of the accused are in the nature of archaeological propagation and allegations. No evidence of any of the persons who are alleged to have been recruited or joined this struggle inspired by the appellants has been brought before us, thus we are unable to say it. So what, Malads, is the covert or overt act that is attributed to me? None, other than that speech. And the High Court doesn't go into this. We cite Vernon in the High Court. The High Court takes no note of it. And this judgment came while my SLP was pending, which is why, Malads, change of circumstances, I said, let me go back and I'll argue all this. Malads, para 47, if your lordships may see also, the second set of materials include witness statements. There also no covert or overt act of terrorism has been attributed to the appellants by these three witnesses. We have dealt with a summary of their statements. No covert or overt act as far as I am concerned. I am in conspiracy, Malads. That's the 59 FIR.
Between classicum D and E.
Yes.
In the paragraph 46, which you read, Mr. Sibal,
B.
that's reference to the active last but one sentence.
Yes. Reference to the activity. Ideological propagation.
Evidence of any of the persons who are alleged to have been recruited or have joined the struggle inspired by the appellants has been brought before us.
Correct.
Their contention is that your speech, provocative speech,
You've heard it, Malads. Your lordships can form an opinion. If it is
no, that is their contention.
I know that, Malads. I have only placed the speech before you, Malads. Now it's for your lordships to decide whether it's inciting.
You have to come out with that.
No, that your lordships will have. I can only place the speech before you. If this is the speech, then many of us, Malads, are liable to go to jail. Many of us
have our own reservation as to whether we will go into merits.
No, we don't. I didn't. That's why, if your doctors will remember, I never argued the merits. I only went on the legal proposition and the case law which Dr. Singhvi has cited, which I cited at the beginning.
If so, to what extent? These are all issues.
That's correct. Well, and I don't think at this stage, when I have undergone more than 5 years, it's necessary for your lordships to go into all this. Because what's the public interest, Mullahs? There are two public interests to be served. Number one, if I come out, I shouldn't continue to do activities which may threaten the state. Surely, Mullahs, I can't as a single person do any of that. And your lordships have enough power to ensure that that cannot happen. The other public interest to be served is, why should you let this man be inside for another 3 years or 4 years or till the trial is over? And what's the public interest to be served? In other words, this is punitive. I am innocent till I am proved guilty. And this is in the nature of a punitive act by the state to ensure that I continue to be in jail for a lesson to be learned by other students of the university that don't do any of this. After all, Mullahs, Chakka Jam is something that has happened throughout the country. Mullahs, I remember even during George Fernandez days. Your lordships will remember. Railways, Mullahs, not allowed to move. That's more than Chakka Jam. During, Mullahs, the agitation in Rajasthan, the Gujar agitation in Rajasthan, I remember people lying on railway tracks. Don't allow the trains to move. The Kisan agitation, no UAPA for any of them.
Sikh rights also was there.
Sorry?
Sikh rights.
Sikh rights, people were prosecuted and rightly so.
No, whether it was there, this Chakka Jam was there?
No. Sikh rights, what happened was, in fact, I was one of the counsel who was designated by the court to go across and to give a report to the Supreme Court as to what happened. It was horrific. What I saw was horrific. And no human being with any sense of any values can do something like that. What have these kids done? And they are protesting against, it's a valid protest. You may say it is in excess of what they should have done. You can say that, but you can't say it's a terrorist act. You know, 144 is imposed, you go and do something. You can't say it's a terrorist act. I mean, there are other ways to deal with it, not 5 years in jail and we having to argue for so long to figure out what should be done.